What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody? Welcome in. We've got a jam-packed one today, trying to get in a bunch of little tidbits and details and legal angles to discuss with you on this Idaho 4 case. There's been things happening in other cases as well, which we're going to talk about one of those today. But I also wanted to just mention, we're only a couple weeks away from the Alex Murdaugh criminal trial in South Carolina and the Sarah Boone trial here in Florida, in my backyard-ish, in the Orlando area. If you guys don't know about those cases, go check out our playlists so that you can get up to date on two of the wildest cases, factually speaking, that I have ever seen in my entire career. So check out those playlists and make sure you are caught up on those cases. January 23rd, Alex Murdaugh starts, and January 30th. And January 30th is when Sarah Boone starts, okay? So hit that subscribe button. You'll get alerted when those cases are going on as well, so you don't miss any of the trial breakdowns, and you'll see kind of how this channel, if you're new here, breaks down trials, and we talk about it each day. Somebody's saying the sound is one-sided or they can't hear. Sound is fine. Other people saying no sound. Some people are saying great. Well, this is always a nightmare when this happens. Let me see here what we can do. All right. People are saying it's just fine. We're going to have to keep rolling. We got a new mic. We'll talk about that later. Hopefully you guys can hear it just fine. Sorry if your sound is not fine. All right, everybody's saying I have sound. Sound is fine. Okay. All right, let's just keep rolling with it then. So we've got a lot going on, so make sure you hit that subscribe button and the reminder bell so you don't miss any of it, and like this video as well. So today, just to give you a little breakdown of what we're talking about, we are going to go through the stop, the traffic stop in Indiana. We're just going to go through one of them because I think it's the better one to kind of illustrate our point. And we're going to talk about whether or not the FBI actually directed that stop. And it's funny that we've gotten more answers today from what we were going to talk about yesterday about this stop, whether or not the stop was unlawful, what makes it unlawful, what potentially it would be fruit of the poisonous tree. We'll talk about what fruit of the poisonous tree is. Azam asked that yesterday. We're going to dig into that today. We're going to talk about whether or not any evidence potentially could be used in this case that would be fruit of the poisonous tree, which means Bryan Kohberger and his lawyers would be able to exclude it. We'll talk about that as well. And we are also going to talk about, a lot of you have asked about the insanity defense and whether Bryan Kohberger could use that sanity defense. A lot of you have astutely pointed out that Idaho does not have a traditional not guilty by reason of insanity like Florida. But there are some arguments where mental capacity could come into play, that you could make those arguments to where you end up being not guilty because you do not have the ability to form the criminal intent necessary to commit those crimes. We're going to talk about that today by illustration of another case in Idaho. We are following and have been following the Lori Vallow and Chad Daybell case. Things have happened there. Her lawyers have filed motions, and we have found out whether or not she seeks to use mental capacity as part of her defense. And we know there are a lot of mental health issues in that case, as she has been found not competent to stand trial for multiple months during the criminal litigation. So we're going to get to that, and we're going to kind of apply it to Bryan Kohberger as well, because both of these cases are in Idaho, and they'll explain what the right of, or what the way how the way the law works and the rights of the people in Idaho when it comes to the insanity defense. All right, hold on. All right, let me know if, hopefully the sound, somebody else is saying no sound. Hopefully the sound, yeah, if your sound is off, refresh and rejoin. Is that any better, John? Thumbs up, down, anything? All right. We're going to keep riding. Sorry. Sound is in stereo. Is that the problem? I don't know. I can't tell. All right. If it was your issue, we'd all have issues. Somebody said, okay, sound is perfect. All right. I got to keep rolling here. So, when we talk about these cases and we talk about this stop, right, we've already kind of discussed it as well. And we went through the stops together. We listened to both of them. The real question was when Fox reported that a anonymous tip came through that the FBI directed the Indiana police to pull over Bryan Kohberger and his dad on the way from Idaho to Indiana, that could be problematic for a number of reasons, right? Usually law enforcement does stuff like this. It doesn't really end up mattering. So it's just another way that they kind of toe the line, and another way that the public kind of loses faith a little bit in law enforcement, because when there are gray areas, they're going to take advantage of it. And in our opinion, especially in my opinion as an attorney that literally fights for constitutional rights for people on all sides of the line, it's really disturbing when they don't care about constitutional rights and they say it in the name of, well, we got to get the guy or we got to get the girl who did this, and we've got to make sure we convict the person, rules be damned. And, we're just not about that here on this channel or as attorneys. So that would be problematic if they were using resources of other states and pulling people over for no reason or no valid reason and trying to get information that they otherwise would not be entitled to. So that would be problematic, right? But I was going to say that I would be shocked. I would not be shocked if the FBI did, in fact, direct this. What I would be shocked about if they admitted it and they actually said, we directed the Indiana State Patrol or Highway Patrol or whatever to pull him over for following too closely and try to get information from him. I would be shocked if they actually admitted that. And come to find out, I think I have it up here. I have a bunch of stuff to show today, so technical difficulties kind of suck. I was hoping to show a bunch of different things. But Andrea Burkhart, who's another great lawyer here that makes YouTube videos and does stuff on Twitter, she put up there that the official statement from the FBI is that, contrary to reports, the December 15th traffic stops conducted on the vehicle being driven by Bryan Kohberger in Indiana were not requested or directed by the FBI. So we have the official statement now of the FBI saying we did not do this. So we can kind of throw out that Fox report, in my opinion. And again, when I initially prepared for this video, I was going to say highly doubtful they would ever admit it. Comes out, they don't admit it. So why did we even think that it was possible, or why do we still think it's possible, even though they've made their official denial that they directed this? Why would we even think that? What context gave us that in the discussion when we were talking together? Well, number one, as we talked in the comments, many of us have never in our entire lives of 20 plus years of driving have we ever been pulled over for following too closely. So the fact that he was pulled over twice in one day in one state of following too closely is a little bit fishy. Number one. Number two, neither officer got anywhere close to giving Bryan Kohberger a ticket. So if it really was a traffic violation, he did the same thing twice. I know one was speeding, but they also talked about following too closely, and he told them that he had already been pulled over. Very strange that the second one wouldn't have given him a ticket, right? I mean, I was always nervous if I got pulled over one day and they gave you a warning, especially as a kid. Now you know that pretty much means nothing. But when you're a 16-year-old, 17-year-old kid, you get pulled over once, and they give you a warning, but they're going to document it. If you were to get pulled over the same day, you would think you'd get a ticket that second day, right? Well, he didn't get a ticket. They didn't even ask for his registration. They didn't really do much digging. They did get his ID, and they did ask him where he's going and where he's coming from. So that's interesting. All right. So now we get to the information they were actually trying to get in these traffic stops. What information do you think they were trying to get? You guys have seen them. We are also going to, hold on. Somebody just said to play devil's advocate, which, I always love. I think she said to play devil's advocate, my husband's gotten a ticket for following too closely. And that's fine. He got a ticket for it. He didn't get pulled over twice and get 2 warnings with nobody even asking for his registration, right? So I think there is some fishy surroundings with these stops, but it is what it is. Okay. So what information were they trying to get? I think we have more context, right, with the probable cause affidavit. I think they were trying to confirm it was in fact Bryan Kohberger. They got his identification card. that he was in the suspect vehicle, the white Elantra, 2015, I think it was. They confirmed where he was going and where he was coming from, so he wasn't on the run, and they were still able to follow him and track him. Maybe you guys actually pointed this out to me, which was a good point. I didn't think of this, but you all pointed out maybe they were trying to confirm that he didn't have a hostage in the car, right? If he had just committed those heinous crimes a couple weeks prior, then maybe they did want to confirm it wasn't a hostage in the car. So I think that was a good point made by you all. They could have wanted a free look inside, the old plain view doctrine. If they walk up, they see something in the back seat, on the floor, on the driver's side, whatever it may be, whatever they can see in the car in plain view for a lawful traffic stop is totally fine. And then a lot of you pointed out potentially injuries to his hand or his wrists or forearms or whatever it may be. And from my perspective, when it's, 4 to 6 weeks after something like this happened, I don't know if that would have really been great evidence. A lot of you saw some stuff in the pictures. I didn't see much, but I could be convinced of stuff if it was slowed down or zoomed in or whatever, and there was some medical testimony on it. But, broken bones often heal in 6 to 8 weeks is one of the common timelines for broken bones. So scratches, cuts, bruises, a lot of that would be healed by the time this traffic stop occurred. Also, as in many of my cases, people say, oh, it's been 6 months since the accident. They could have done something else to hurt their neck or their back or their shoulder or whatever it is. Well, 4 to 6 weeks from the crimes happening, he could have done something else to hurt his hands or his wrist, right? So I just don't think that would have been necessarily hard evidence, but nevertheless, potentially that's something they were looking for, right? So Andrea, I'm going to bring her up again because she posted a good article from, or not an article, but an explanation from Cornell Law School site, which we're going to use this a couple times, but I wanted to shout her Twitter page out here, so I'm going to share hers. Her post of this because I thought it was interesting. And she's gotten in the Twitter comments sometimes with you all answering questions that you had on my Twitter. She's got a huge Twitter following. She's super smart. And so that's cool whenever she gets into the comments as well, and you guys can kind of chat with her. And she puts up here how it could become a violation of Bryan Kohberger's Fourth Amendment right to unreasonable search and seizures. And this is an absolute gray area, in my opinion. Okay, so let's read it. A seizure for a traffic violation justifies a police investigation of that violation. So it has to be connected to the speeding or the following too closely. It cannot be connected to any murder charges or anything like that when you pull somebody over for something like this. If you don't have the probable cause, of course, to arrest them already for the murder. A relatively brief encounter. And we're going to get into definitions now, and I'm going to have you guys tell me whether or not you think this was a relatively brief encounter or if it, quote unquote, crossed the line. A routine traffic stop is more analogous to a so-called Terry stop than a formal arrest. Yeah, somebody's not detained, stopped, movement stopped, even though they technically are. Like a Terry stop, the tolerable duration of police inquiries in the traffic stop context is determined by the seizure's mission to address the traffic violation that warranted the stop. So, were you drinking anything? How long have you been driving? Are you tired? Are you on any medication? All of that is appropriate to see if that's maybe why they're speeding or following too closely because they aren't paying attention or they're rushing or whatever it may be. Those kinds of questions are connected to the violation, just to give you some examples. The scope of the detention must be carefully tailored to its underlying justification because addressing the infraction is the purpose of the stop. It may last no longer than is necessary to effectuate that purpose. And that's one of the important quotes there. The stop cannot last longer than is necessary to effectuate that purpose. Okay, authority for the seizures thus ends when tasks tied to the traffic infraction are or reasonably should have been completed. So if you last longer than you should or than you need to complete that traffic stop and deal with the violation, then you've crossed a line. Okay? In determining the reasonable duration of a stop, it is appropriate to examine whether the police diligently pursued the investigation. Our decisions in Cabales and Johnson heed these constraints. In both cases, we concluded that the Fourth Amendment tolerated certain unrelated investigations that did not lengthen the roadside detention. So they have found in the past that even if it is a little bit longer and you have some unrelated discussions like maybe where are you going, where are you coming from, how you guys doing, Some unrelated discussion is okay. The Supreme Court has found that. However, we've cautioned that a traffic stop can become unlawful if it is prolonged beyond the time reasonably required to complete the mission of issuing a warning ticket. And we repeated that admonition in Johnson. The seizure remains lawful only so long as unrelated inquiries do not measurably extend the duration of the stop. An officer, in other words, may conduct certain unrelated checks during an otherwise lawful traffic stop, but contrary to Justice Alito's suggestion post, he may not do so in a way that prolongs the stop absent the reasonable suspicion ordinarily demanded to justify detaining an individual. Okay, so that gives us kind of an idea of what the law is on the Fourth Amendment and what law enforcement officers are and are not allowed to do when they pull somebody over for a traffic stop, even if they are a suspect in a much more serious crime. Okay? So, now that we've read that, let's watch that second stop one more time. Okay? And right off the bat, if I'm an attorney for the prosecution and Kohberger's attorney filed a motion saying that this violated his Fourth Amendment right, I would have a pretty simple beginning to my argument that this entire body cam video is 2 minutes and 47 seconds. I mean, how brief can you really make a traffic stop, right? All right, let me see here for audio. Should be good to hear it. All right, here we go. Let's watch this together. So here's what I want you guys to look for, okay? As we're watching this video together, keep in mind what we just read, that it has to be reasonably connected to the violation. They can't stick around any longer than they would need to or than is necessary for that, besides some brief unrelated discussion, which is okay. All right, so as we watch this, what I want you to look for is if you think law enforcement crosses the line of doing what was necessary for the following too closely stop and cross the line into things that were not reasonably related to that. Okay, so let's watch this, and if we see anything, go ahead and shout it out in the comments or in the chat, and we'll talk more about it after we watch it.
Hello.
How you doing?
How y'all doing today? Good, good. Take a look at your driver's license real quick if I could. See, he's right up on that van, man. He was right up on the back end of that van. Pulled you over.
So pretty clearly right now, no issue, right? He said, you were really on top of that van. Can I get your license?
For tailgating. Is this your car? Okay, cool. Where are you headed?
Is this your car? Again, appropriate question in this situation, and any traffic stop, frankly, is this your car is an appropriate question. Somebody pointed that out in the chat, that maybe that's the information they were trying to get. Is this white Elantra actually Bryan Kohberger's?
Well, we're coming from WSU, and we're standing early.
What's WSU?
University, basically. That is SWAT team and everything.
So then it just, where they're coming from morphs into this conversation about the shooting at WSU. You guys tell me, right? I am a defense lawyer. I argue the other sides of these motions to suppress all the time. To me, this is not digging past just minor, unrelated conversations. Has he even handed him his license yet? I mean, he's waiting for him to hand him his license at this point still.
Okay.
Oh, no, he's got it in his hand. He's got the license in his hand. All right, I hear a lot of you complaining still about the audio. Let me just try one last thing. All right, let me know if that's any better for the audio. Hopefully it is. If not, we'll try to figure it out by the next video.
Traffic. So you're coming from Washington State University, and you're going where? Oh.
We're going to be going to Pennsylvania.
Oh, okay.
Yeah. We're slightly punched because we're driving for hours.
Hours, days.
Hours. We're driving. Well, almost a day.
Okay. And what did you say about some SWAT team thing? Or
Yeah,
what?
there was a mass shooting and everything.
Where?
All right, people are saying that fix it, but they're also saying much, much louder. So I apologize. Fix your audio here. Here's the chance for everybody to fix their audio. Okay, it seems like that's working for everybody. Just fix the problem. Good deal. Okay, so I will tell you also, it seems to me like Bryan and his dad are the reason this stop took 2 minutes and 47 seconds. It would have been even quicker, I think, if they just would have said nothing or just would have said coming from Pullman going to Pennsylvania. That's all they would have had to say. But they bring up this story that creates the conversation with law enforcement, in my opinion.
Interesting.
Well, it's horrifying because he's going to the universe. You know what I mean?
Mm-hmm.
It's so, I mean, ironic if Bryan, in fact, did this, that his dad said it's terrifying that this would happen on the university. Just really, really interesting.
So y'all work at the university there?
I actually do work there.
Oh.
All right, so here's something potentially. Now, I still think this is in context with the story that Bryan and his dad brought up, but asking him or them if they work at the university potentially could be the first chance we see at law enforcement crossing the line, so to say. What do you guys think? Is this now going too far? Could he have just cut it off? He asked this question to continue the conversation. Is this crossing the line?
Okay. Okay. Yeah, I hadn't heard about that incident. Just yesterday, or?
This happened about an hour and a half ago. We're still wrapping it up for investigating.
And to me, additionally, yeah, people are saying this is normal human interaction, but what the law enforcement officer could get is their reactions in the way they talk about this. I think there is something to be learned. I don't think they learn much from it, but you know, if he would have started freaking out or getting nervous about talking about a massacre at a university, which I mean hits close to home, I do think something could have been gained from that. But in my opinion, I don't really think much happens here.
I'm not sure there's two shootings because they did shoot somebody.
Let's see.
And then you don't know about that actually. They were there, they were shooting out of the window or something.
Interesting. Wow. Okay. So do me a favor, don't follow too close, okay?
Oh,
all right. Thank you. Appreciate you.
All right. So it's even less than that, right? It's even less than 2 minutes and 47 seconds. It's 2 minutes and 30 seconds. So I personally don't see a ton there, right? I personally don't see a ton there that violates his Fourth Amendment. Okay. Let's get to some questions before we talk about the fruit of the poisonous tree here. Patrick, thank God it's Friday. And lawyer, you know, fam, what's up? We do recover. Thank you for the super sticker here. Jennifer Landers, thank you for the super sticker as well. Azam asked yesterday what fruit of the poisonous tree is, right? And fruit of the poisonous tree is simply saying, if a tree is poisoned, all of its fruit is poisoned. You cannot eat that fruit. You cannot use that fruit. And a tree in an investigation becomes poisoned when a crime is committed or somebody's rights are violated. So if evidence is obtained illegally or unlawfully based on, you know, violating a constitutional right, like the Fourth Amendment, if this was an unreasonable search or seizure, anything they would have found or gained as evidence would have been fruit of the poisonous tree. We've got some new members here. Thank you. Snyder, Rainey, HW, don't be a jerk. I like that one. And Kayla S. So when we talk about fruit of the poisonous tree, if you feel like the evidence is poisonous because it was obtained illegally or because somebody's rights were violated as a criminal defendant, the defense lawyer will file a motion to exclude that evidence. And if we look at this case and we try to figure out what potentially that could have looked like, right? And I saw in the chat, most of you don't think that it crossed the line. And I do want to get to those questions here. I want to get to some of those questions here before I give my answer. Mercedes McLaughlin, one question to him was, is this your car? Kohberger said yes. Was that of any significance? So if we think back, and this question is great because we have the context of the probable cause affidavit now, where literally the only bit of evidence that came out of a 19-page probable cause document, one line said, and it was still in his possession as he crossed state lines into Indiana on this date, December 15th, whatever it was. That was it. So frankly, this question, give me your ID so I can tell you're Bryan Kohberger. I see the white Elantra, and you've confirmed that it's your car. That's basically all they used in the probable cause affidavit. Cheryl Meme. Hi, Peter. I first came here for your drop-dead gorgeous looks, but I returned because your analysis is always fair and unbiased. P.S. Great Grammy can still look. Keep up the great work. Thank you, Cheryl, and I'm glad you're sticking around because, looks may fade. Michelle M. Isn't it possible one or both were due to the Elantra itself with Washington plates? At the time, Idaho LE had only asked for help with an Elantra, right? Yes, and we know for a fact other states were looking into this. So were they just pulling over every white Elantra? If I was the defense attorney on the case, I would try to get that data. I would order these body cams of these law enforcement officers, both of them that pulled over Bryan Kohberger, and see how many white Elantras they pulled over that day or even the days before, once that bolo basically for looking out for white Elantras went out to everybody else. I would be interested in that information, because if they did pull over, 25 of them, fine. If this is the only one they pulled over, they were zoning in, they were zeroing in on Bryan Kohberger, which if you read the probable cause affidavit, which we did together, check out that video. It's on our playlist if you want to, and you weren't able to catch it. They were starting to zero in on him as early as November 29th, getting his name and information connected with the Elantra and Pullman. Lauren Hers, did y'all notice that when asked where they're going, Bryan goes to get Thai food and his dad was like, no, Pennsylvania, and the death glare? Yes, I did. Oh, okay. Sorry. I thought there was another correction. Yeah, I did notice that. And that is the one little thing I think you can pick of. Was he trying to be deceptive there, but the dad wasn't having it? P-Hop, why would they bring up the mass shooting and something about the dad? Here's his correction. Something about the dad is weird. I thought the dad seemed totally normal and nice and just talking about, whatever, and how a normal person would think if they heard about a school shooting where their son was going to school and working. And I don't know why to bring it up, right? It could be nervous energy where that's the first thing that popped into your head. It could be really what they were just talking about, right? And that comes out. Monique and DF are two new members. Welcome, peeps. Just BKZ, could the officer have inquired about impaired driving if he was punchy for driving from hours for so many days, especially with tailgating? I agree. You would think this is why I think there was something else going on here. Whether it was directed by the FBI or not, I don't know. But it seemed like there was something else going on here, because a normal traffic stop, you would potentially be like, are you sure you're okay to drive? Have you taken any medication? Are you drinking Red Bull? Like, are you switching off driving? Those are the questions I would have asked after they, I don't know if that might have been in the other stop or whatever. I can't remember if we just watched this one, but I've watched them both so many times. But to say that, yeah, he was like admitting, sorry, we're so tired. We barely even noticed we were tailgating is what it sounded like, I know he didn't say that specifically, but I get where you're coming from. Chris Online, this is what is known to law enforcement as a whisper stop. Eyes were on him cross country. He was stopped for an ocular pat down. They may have needed him to slow down so they could catch up. Chris, this is a good point, right? Cosby was let go because of fruit of the poisonous tree. Just one. Yeah, that's one of the reasons. But yeah, there's lots of cases. I mean, you guys would probably be appalled to go through some of the cases that were affected by the fruit of the poisonous tree doctrine. I find it interesting that when asked, where are they going? Bryan says somewhere else, and his dad corrects him to say Pennsylvania. Thoughts? Yeah, Mr. Jesse. I think this is the one kind of interesting part about what they said. Although it could also be true where he was just saying they're going to get Thai food, right? I mean, that could also be true too. So, and I think the dad, potentially arguing devil's advocate, the other side here, they both could have been thinking about it different ways. Bryan was thinking immediately we're going to get Thai food. The dad was like, no, he asks where our final destination is because we said we're coming from Washington State. Final destination's in Pennsylvania. So I think there is an explanation there, but I get it. There could be more there. Jennifer Landers, this question is really from yesterday, but would DM need a lawyer with the possible scrutiny she will get for her story? Potentially. I don't think it ever hurts to have a lawyer protecting your rights. Lita Randolph, every traffic stop I've been involved in, the cop goes back to his car to look up if I have a record, etc. I agree. They almost always go back to their car with your driver's license or registration or whatever, type something into their computer, and they didn't here. These are the indications because it's an abnormal stop to me. It's almost like if it was going to be this brief of a stop and such a non-issue and no big deal, this following too closely, then why even stop him at all? Beth, does any of this even matter? If they want to use the stop as evidence, they don't prove much to me. Beth, we are going to get to this answer. I'm going to leave this one up because we'll get to it later. Sandra, I'm a former 911 dispatcher. I've seen some wild movies of people in your position. This stop is much shorter than most I've dealt with. Factors such as running a license or tag through NCIC can take longer than the stop. I agree with you, and I appreciate this context. I love when you guys bring your backgrounds and your experiences into this because I agree with you. And these are the things that tip us off a little bit that maybe there was more to this stop than really just following too closely and giving a warning. Southern Mama, I've been watching way longer. Also, if they were looking for him, wouldn't they be more cautious? I mean, he is a possible murderer. It's a good counterpoint. A really good counterpoint. Diane Widener is a new member, and Andrea Taylor, thanks for the super sticker. All right, so here we go. Let's give a little example here. If Bryan would have been pulled over following too closely, and they talked to him for 45 minutes, ask if he's former military, ask if he's ever used the type of knife in question. He says maybe. They stick their hand in the car. They see the knife. They grab the knife from off the floor or the glove box or whatever it may be. They seize the murder weapon. They take him into custody right there. And now they've got this evidence that they got from this stop that lasted way longer and had nothing to do with following too closely. Now, that was an overly obvious example to kind of prove our point, but that to me is what it looks like to really go overreaching and violate someone's Fourth Amendment. Now, everything between the stop that we saw and the analogy I just made, there is a ton of gray area on what constitutes an unreasonable search. It does not have to be as egregious as my example, but I don't necessarily think this stop rose to that level. Okay. Now, when we talk fruit of the poisonous tree, there are exceptions. And I've mentioned some of those exceptions, but we're going to give a little bit more time to them right now. The major exception is inevitable discovery. That means regardless of the fact that they got the evidence right now, they would have gotten it eventually anyways. And that's where it comes down to the fact that who is this Bryan Kohberger? Is this his car? They already had that information, but they would have gotten it later as well. Where was he going? Pennsylvania. They end up following him because they are allowed to and get him in Pennsylvania. So that's all things that they were inevitably going to discover. So the important factors that even may have come from this stop were going to be inevitably discovered anyways. So I don't think fruit of the poisonous tree would apply. And I don't think any of that evidence could even be excluded, even if they wanted to. Now, in my example, if they would have found the knife, would that have been inevitably discovered? And some people would argue that, well, they were going to arrest him. They had the arrest warrant already drafted. They got the DNA, though, once they were in Pennsylvania, right? So once they were in Pennsylvania, that's what I think was the hook for the arrest affidavit. They probably started it, and they had a lot of the evidence at this point. I may have said that they had the arrest affidavit already, or the probable cause, but they probably didn't because they needed that DNA match, which they got from the trash in Pennsylvania. So at this point, if they would have gotten that knife, would it really have been fruit of the poisonous tree? Because we know they searched his car incident to arrest. We know they can do an inventory search once they take his car, once they arrest him, when it's, involved in the crime. So they would have inevitably searched his car. However, they wouldn't have searched it at that exact moment. He could have removed the knife. He could have done a lot of things. Now, a blood stain on the back seat or on the floor, maybe that wouldn't have come up, and maybe they would have inevitably discovered that. But something like a knife or a piece of evidence that could have been removed, that probably would be fruit of the poisonous tree and would be excluded as evidence at trial, which would be wild to think if we had the murder weapon, but the jury never knew about it or didn't ever know that they discovered the murder weapon. Could have been very, very wild at that point. All right. Let's see what else we have here. All right. So that's all we have as far as the, traffic stops. I'm going to get to a couple more of your questions. We've got two more things I wanted to hit today. We're going to do the Lori Vallow section first. So John, you might want to write down the timestamp here after these questions, but we're We're going to do the Lori Vallow, the insanity plea, how it works in Idaho, because they don't actually have a not guilty by reason of insanity defense, how Bryan Kohberger could have that apply to his case. And then I also have the video from the hearing yesterday. And oh, shoot, there was one other thing. So yeah, so there, I have that video. I don't know if we'll be able to get to it today. We may have to save it for another video. So before we get to Lori Vallow and before we get to your questions, we talked a lot about that Reddit post and whether or not it was legit. It ended up in the probable cause affidavit, which means law enforcement thinks it's legit. Now, whether or not it actually becomes a piece of evidence is still yet to be seen. But let's take a look at that Reddit post together and how you can see why this is very interesting to see if it is, in fact, real. Research participation needed. Hi, or hello, my name is Bryan, and I am inviting you to participate in a research project that seeks to understand how emotions and psychological traits influence decision-making when committing a crime. In particular, this study seeks to understand the story behind your most recent criminal offense, with an emphasis on your thoughts and feelings throughout your experience. In the event that your most recent offense was not one that led to a conviction, you may still participate. Additional surveys are included after the open-ended section as to best understand your unique traits. The study should take about 15 to 20 minutes to fully complete. Your identity and all answers provided are completely confidential, and the link to the survey is also an anonymous link. This research has been approved by DeSales, I think is how you say that, University IRB. Participants must be 18 years of age and older. If you opt to participate, you may terminate participation at any time for any reason. If you have any questions about this research, you may contact the research team via email. Bryan Kohberger is the student investigator, BK5781 at desales.edu. Looks reasonably legit. Law enforcement thinks it's legit. So I wanted to just have all of you guys take a look at that Reddit post before we move on. So Beth, does any of it matter? It doesn't really seem like they're going to try to use much from either of these stops. So to me, I agree with you. They don't prove much. Sarah Bellum, BK giving dad glaring looks, tight-lipped when his dad interjects with PA and dropping his head in anger. Subtle signs. Thoughts? Looking sharp, Pete. Happy Friday, lawyer you know fam. Thank you, Sarah. I don't think there's a ton from that. Potentially they could use this body cam footage, I guess, to say, he was driving from this place to that place. If they think he does look like he's trying to hide something and someone from a jury might pull that from this body cam, they could play it for a jury, but I don't see much personally. Some of you are better at seeing that stuff than me. Nancy B. When the cop asks how long they've been driving, they respond with hours, and the cop says days, like he already knew. Thank you for your continuous unbiased opinions. There's definitely some tidbits there that make me think this was more than just a following too closely stop. EJ, with everything else they have on him, is this just annoying, or can it actually affect the outcome? And how important is the weapon in convicting him? So I don't think that they would even try to use much from this just because they don't want to deal with the, fruit of the poisonous tree or ask it to be excluded or motion to suppress this evidence or anything like that. The murder weapon would be very important, but I think that sheath is just such a huge piece of evidence. And it's so shocking to me that if he really is this, student of the game, as they say, and he tried to plan this perfect murder, that he would leave something so important behind, because I think that sheath basically tells us what the murder weapon is, what the size of it is. And with his DNA on it, it's almost going to take the place of the murder weapon, I think. Rosie, just wondering how many others here learned to be ambidextrous. It was mentioned before. I learned when I snapped my ulna radius and have been ever since. If you're ambidextrous, throw it in the comments. I broke a bone in I think it was my left elbow, so it wouldn't have made me use my left hand. I am not ambidextrous. Aussie, FBI wouldn't send officers alone to a stop quadruple murder, would they? That seems like a dangerous assignment to me. I think this is a good point. And they didn't seem to be overly on guard, right? The officer has both of his hands hanging into the window. He wasn't, nervous or anything like that. So I think this is an argument to the other side that maybe they didn't. Kelly L. It would be an interesting counterpoint if something bad did happen. Would it come back on the FBI? Answer, probably not, because nothing ever does. Kelly L. Your thoughts on the police seeing him wearing gloves, cleaning car, and discarding trash at 4 a.m. in neighbors' garbage while under surveillance in PA? What did they find from that? That's what I want to know, because they went and looked through it. If they saw him do that, the wearing gloves and even the mask stuff, to me, in today's day and age, is kind of hard to guarantee what that stuff could mean. Stephanie Coker, do you think he left the sheath to throw off the scent? ABS make it seem like they were looking for an ex-military person for the perp. Okay, so you're saying he tried to throw him off the scent by thinking this was a military person or ex-military person when he in fact is not. But man, what a big mistake. Because I mean, without that sheath, honestly, without his DNA match on that sheath, I think this case is a lot tougher. Now, they may have more evidence. They may have more DNA evidence. We may still, the probable cause affidavit doesn't have to have every piece of evidence they have, just enough for probable cause to arrest. But that seems like a very, very big piece to me. So that was a big risk if he was just trying to play a game. Peggy Reardon. The FBI released a statement that they did not request either stops. Yes, we read that off the top. That was the very first thing we read, that the FBI denied directing or requesting these stops. Yes. Applejam PB. I'm a former social science researcher. That's a standard call for study participants in line with criminology study. Doesn't sway me. Interesting. Okay. Because I think you all tell me, does that Reddit post sway you even 1% toward thinking he could have committed these crimes, meaning Bryan Kohberger? The actual survey would be more telling if it's online. I agree with that, Applejam, but that's a really good perspective in how each individual person's background and experience affects the way they see the same piece of evidence. So if you were a potential juror and somebody was asking you about your experience and your background, that would be important to know. But we as the lawyer, and now I know this, and this is something that's going to stick in my head, realize that, and this is kind of how we feel about all professions, is you can get a little callous to this stuff. And for you, this may seem normal. Like a lot of the stuff I deal with and talk about every day, a lot of you would not feel like it was normal. It would be very difficult to get through the day. You get used to it and you're able to talk through certain things that other people aren't because of the experience that you have. Brown-eyed girl. Do you think it's possible that the victims were fighting him and he dropped the sheath? Yes, I think it's possible. I mean, he didn't sprint out of the house, right? If we listen to the eyewitness testimony, he just walked slowly down the stairs, turned around and went out the back door. So gosh, I don't know. It would just be so surprising to me if he made that, mistake, as we say. Sheena Fleming, welcome to the crew as well. All right, let's transition to Lori Vallow here. Another case in Idaho. If you haven't been following it, it's a wild one. And I encourage you to go check out the playlist for all the background. A lot of people are saying no, yes, way more than 1%. So kind of split on that survey. All right, so let's switch to Lori Vallow here. It's a wild case in Idaho. I encourage you to go check out the playlist to get a better and fuller background than I'm going to give you here. But this is somebody who was allegedly a major part in deep inside a cult, has been accused and charged with murdering her children, among others, and with her new husband. And she has been found mentally incompetent to stand trial, meaning she didn't understand the process. She wasn't able to aid in her defense or discuss her case or defense with her attorneys. Therefore, they paused the case. Discovery has stopped multiple times. So there have been mental competency issues throughout this case. But as we know, and as we have discussed in the past, Idaho does not have a traditional insanity defense, meaning not guilty by reason of insanity, just like we broke down the case in Florida, where the young, I think he was a college student, murdered two innocent people and was like eating their face. And he ended up just not even getting tried because all the medical professionals agreed at the time he committed the murder, he was legally insane and therefore could not be prosecuted, tried, and convicted of murder. They don't have that type of insanity plea in Idaho. But we are going to discuss the mental health defense and the aspects that it can provide to a defense in Idaho. The basic defense is because of your mental health or your mental incapacity, insanity, whatever you want to call it, at the time of the murder, you were not able to form the criminal intent or mens rea, as it's known, to commit the crime. You did not intend to hurt someone. You did not intend to kill someone because of that mental defect. So I think a good way to illustrate this is to explain two different scenarios, one of which you would be able to use this mental health defense to part of one of the elements, and one of them you would not. Case number one, and we've done this before, so this is going to be kind of a redo to help us understand what insanity actually is in Idaho. The defendant, due to insanity, believes that the victim is a wolf. He shoots and kills the victim, in his mind, the wolf. Case number two, the defendant, due to insanity, believes that a wolf, who is a supernatural figure, kind of seems like a case that we're talking about, has ordered him to kill the victim. And if you hear some of the discussions around the Lori Vallow case, she was told that they were zombies. Her kids were zombies, and the only way to free them was to kill them. So the second case, the wolf, the supernatural figure, ordered the defendant to kill the victim, and so the defendant listened and killed the victim, a human being. In case one, the defendant does not know he has killed a human being, and his insanity negates a mental element necessary to commit the crime. So in Idaho, that would be a successful defense, and you can beat a murder charge with that defense. In case two, on the other hand, the defendant has intentionally killed a victim whom he knows to be a human being, and therefore he possesses the necessary mens rea. So in both situations, due to insanity, the defendant is unable to appreciate the true quality of his acts and therefore unable to perceive that it is wrong, which is what a lot of other states use. But in Idaho, you can still be convicted under scenario 2. All right, so with that being known and with all the mental defects that we've already know are part of this case, let's take a look at the motion filed. When was it filed? January 3rd, 3 days ago, in Lori Vallow's case. Will they use this mental defect or insanity defense in their case? Because you have to put the other side on notice, because there's going to be mental health experts. It's going to be a big part of discovery. It's going to be a big part of the arguments. Insanity cases are usually almost like two trials, right? The factual trial of did they do it? How'd they do it? How do we know they did it? But then also, can they even form the mens rea or the criminal intent for this crime, even if they did do it? So it's almost like two trials. It's a big deal. You have to put the other side on notice. It can't be a surprise defense. All right. Here we go. Comes now the defendant, and pursuant to Idaho Code 18207, give notice of their intent not to raise a mental health defense at the guilt phase portion of the trial. So if it's a death penalty case and there's a penalty phase, they may bring it up at that time, and they're reserving that right. Idaho Code 18207 provides that a list of expert witnesses be disclosed at least 90 days prior to trial if the defense intends to call the experts to negate an element of the crime. This advanced disclosure is required for the guilt phase portion of the trial. Let's figure out now if we can get any inclination as to how they came to this decision to waive their right to make this argument. The defendant's mental health has been evaluated and litigated. Just lost it. And litigated since the first filing in this case. She spent 10 months at a mental health facility in Idaho and received mental health care from the experts employed by the state of Idaho. The defense hired 3 independent mental health experts to review and evaluate her mental health. Due to ongoing mental health concerns, while this case has been pending, the court conducted an evidentiary hearing on November 10th, 2022 to determine if she was competent to stand trial. On November 15th, the court ruled that she was now competent to stand trial. Although still suffering from a mental illness, and competent to stand trial is very different than insanity. We've done videos on this in this playlist, so if you want to check them out, check out the Lori Vallow Chad Daybell playlist. She has previously reviewed all of the discovery provided to her by the state and her attorneys. She has consulted with the 3 mental health experts. Okay, so she is able to participate in her defense. She understands what's going on. She understands the charges against her. However, it's interesting that they put this in here. She does not want to proceed with a mental health defense to negate an element of a crime in this case. She, Lori Vallow, has not authorized her attorneys to proceed with a mental health defense in the guilt phase portion of this trial. Okay? Now, what do her attorneys think about this? Well, her attorneys are respecting her autonomy and her rights granted to her by the Constitution of the United States. Now, listen, they didn't say this. I don't like to put words in people's mouths, but it sure seems to me like her attorneys think she should be arguing this insanity defense, at least to an element of the crime that they're allowed to in Idaho. This is the Lori Vallow and Chad Daybell case. So it really seems by that paragraph that her attorneys wanted to do this, she didn't want to, and they are respecting her decision. If she is found innocent of the charges, so somebody said, is a zombie equal to a human under the law, Naomi? I think that would be an argument. And I think potentially her attorneys want to make that argument, but she doesn't want to. And that could be part of, she doesn't want to turn her back on, call it cult, call it, religion, whatever it may be. Okay. I don't want to besmirch any religion. I don't know the ins and outs of what she necessarily is going to believe. Brianna, I know, and I feel like a lot of people, that's true. We are going to apply this to that case. So don't worry, stick around. We're going to apply this and how this could affect Bryan Kohberger. So it really seems to me like her attorneys wanted to make this argument and she said no. And it could have been, again, because she still believes everything that she believed before was true. If she is found innocent of the charges, then no such disclosure of expert witnesses will be necessary. If she is convicted by a jury, then the defense will call witnesses, including experts, in support of mitigation during the sentencing hearing. And because we watched the Nicholas Cruz sentencing phase, death penalty phase trial here in Florida together, you understand what that means. They are going to argue, and if you haven't, check out that playlist if you're interested in the penalty phase and how mental health can be a mitigating factor when determining whether somebody is going to get the death penalty or life in prison. There was a multi-week trial on that, and it seems like they're saying if she is convicted, we reserve the right to call these experts and make this argument to mitigate her sentence, meaning lessen her sentence. All right. So now we see what it looks like, and we see that 90 days prior to trial, you have to put the state on notice if you're going to call these experts. Well, we've talked. Will Bryan Kohberger demand a speedy trial? And if he does, it's 6 months. So within the next 3 months, we may find out whether or not he is going to use this insanity to try to beat one of the elements of the intentional homicides that he's accused to have committed. Now, if you compare Bryan Kohberger and what we know so far to Lori Vallow, seems like there are a lot more mental health issues on the Lori Vallow side. However, as a lot of you have pointed out, he has a psychology degree, criminology, PhD, or whatever that he was working on. So with that background and understanding how that stuff works and cloud evidence or whatever he's got his degrees in, understanding how that stuff works, will he try to use that as a defense? Because Lori Vallow, the reason she's not going forward, it sounds like is her decision, a personal decision, maybe even a religious decision against her attorney's advice, maybe. So because it was her decision, and we're going to wait to hear Bryan Kohberger's decision, even if the way that you look at these two cases and you had to place bets on which one would have a mental health argument, you might place your bet on Lori Vallow. The fact that Bryan Kohberger may understand this system, we will have to see if he considers this type of a defense. But usually you have to admit that you actually committed these acts. But because the way that's how it is in Florida, but because the way Idaho does it, and you're just saying it's not one of the elements, you can even make them prove that he was the one that did it. And even if he did do it, that he didn't have the mental capacity to understand that what he was doing was wrong. So it's really, really interesting, right? I don't think he's going to. If I had to guess, I would say I don't think he's going to. But because of his background, it's a potential possibility we're going to keep an eye out for, and he has to put the state on notice. So we're going to know if he, in fact, does go forward with that. No, he's not LDS, Lori Vallow. Two totally separate cases. They both just happen to be in Idaho. And I think they're both going to end up being capital crimes. And Lori Vallow's case is going to go to trial, it seems. So that's the interesting part. And we're going to have to wait and see how it plays out for Bryan Kohberger. But we're getting a little look ahead in Lori Vallow's case in the same state, similar rules, similar charges. So we'll see what happens. All right. To finish out today's video, I have some questions. I'm going to get some questions, and then I think we are going to watch this about 10-minute hearing together on 1.5 speed. So if you want to stick around for that, we are going to get to Bryan Kohberger's hearing where the judge reads in the charges against him, the first appearance in Idaho. Gloria, that would never be a PhD master's question at any uni I know of, and I have lectured at unis in Europe. The Reddit post is creepy. Okay, some disagreement there between chatters. Peggy Reardon, adrenaline will make a person miss a lot regarding the sheath. No doubt. Terry D, Peter, in his eyes are so wide open, he seems scared. I think that's a subjective kind of thing that different people may see differently. But again, different people are going to be on the jury. So some people on the jury may think if that comes into evidence, which I don't expect it would, but if it did come into evidence, they would be able to look at that and see that. Labyrinth. I heard on a podcast that law enforcement like to tip off suspects fleeing so that the suspect makes nervous mistakes and easy to convict. Could the traffic stop have been that? Love your content, Peter. There are so many different angles that this traffic stop could have been helpful and beneficial to the investigation and all law enforcement. So that's kind of why I think it was part of the whole thing. Whether or not it was directed by the FBI, I don't know. But there are arguments on the other side that it wouldn't be part of it as well. Sarah, forgot to mention, Happy Epiphany, aka Three Kings Day, for those who celebrate the day baby Jesus was revealed to the Magi and to the world. And there'll be a lot of Greek boys jumping into the water trying to get the cross. John O'Rourke, late and lost. Quick synopsis. Thanks, chat and Peter. We're going through the traffic stops to see if they were unlawful and if they gained any evidence that may be fruit of the poisonous tree, which Bryan could try to exclude. Seems like not much was gotten there. Seems like it's very, very slim chance that this did violate his Fourth Amendment rights. So I don't think that's necessarily going to happen in this case. Count Time is a new member, along with Tony D and Annie Lee. That was fun. Little rhyme there. K. How did they get a warrant for the phone info? What probable cause did they have prior to the phone warrant? I don't know, but we know based on the probable cause affidavit for the arrest that they did get a warrant for it. We didn't see the details of it, but we saw that they did, in fact, get a warrant for that. Becky Matheson, thank you for the super sticker. Ryan Waters, if Bryan has APD, can that be a factor? We're really going to have to just wait. We're going to have to wait and see what he has and how it could affect any of the elements of the crime. Off the top of my head, that doesn't seem like one that would really work in the way that Idaho does things. Rosie, would you consider doing a video about the pros and cons of the death penalty, maybe with your dad or other law tubers? Maybe. I don't know. I vacillate so much on it that I don't feel like I have a strong enough opinion to really do that just yet. We'll see, though, maybe. Azam, I always remember your wolf example. It makes me understand the insanity plea. Thanks, Peter. Good. And that's the point of giving these analogies. I think they help us understand the process better. So I like to use stories and analogies. That's what makes it so interesting to use these cases to teach people about the law, how it works, how it's implemented, and not just what it says in a book. Okay? Because when you go to law school and you read in a book and you get out, you realize you know nothing. But how it actually happens in real life and how it's applied in real life, I think is helpful. And we see how it's applied in real life. Like, the FBI can just say, oh, no, we didn't direct that. Michelle Woods. Peter, how long do you research laws in other states for your videos, or you already know them and are well prepared? There are some that I already know. There are some that take just a little bit of research because they're very similar to either federal laws or Florida's laws. There are some that I have to take a lot more time on. So it really just depends on how different it is from what I already know. Natalie Biggs is a new member, and Peace and Love Green is as well. Oof, we're going to go a little long today because I feel like we just need to wrap a bow on everything that happened this week in this case. So let's watch this hearing together, the arraignment in Idaho on 1.5 speed. Here we go.
Oh, we got it. Yes. All right.
Please be seated. We're on the record in the Second Judicial District, Latah County. This is the Magistrates Division of District Court. This is State of Idaho versus Bryan C. Kohberger, cause number CR 29222805. Mr. Kohberger is present in court. He is in custody. He is appearing with his attorney, Ms. Taylor, Mr. Thompson, Ms. Jennings, on behalf of the state. This is the time set in the matter for initial appearance. Mr. Kohberger, I am going to advise you of the rights that you have in this case. I am going to go over the criminal complaint with you, and then we're going to discuss setting the matter for further hearing. You have
So she's going to advise him what his rights are. They're going to go through the charges, and they're going to set an additional hearing. Simple enough.
the following rights. You have the right to remain silent. Anything you say can and will be used against you. You have the right to the presumption of innocence. That means the state bears the burden to prove that you are guilty of this offense beyond a reasonable doubt. You have the right to a preliminary hearing. A preliminary hearing is a probable cause hearing. At that hearing, the state must establish that more likely than not, these felony offenses were committed, and you were the one that committed the felony offenses. You have a right to have that hearing within 14 days if you remain in custody. If you are bound over
So we're going to have that within 14 days.
at that preliminary hearing to district court, if the court finds probable cause, you would be bound over to district court. And at that time, you can enter a plea of not guilty, and you can have a jury trial set within 6 months of your appearance in district court. At both your preliminary
That would be if he demands a speedy trial, right? So we talked about that already, but she's now advising him of that he does have the right to have his case go to trial within 6 months. Emma, throw the question up here again. I'll try to see it.
hearing and your jury trial, you have the right to confront and question any evidence or witnesses called against you. Call witnesses on your own behalf and compel witnesses to be present and testify at the state's expense. You have the right to be represented by a lawyer. If you cannot afford one, one could be appointed to represent you based upon your financial need. You also have the right to appeal any conviction in your case. Do you understand these rights?
Yes.
I am now going
So these are rights defendants have in every case. We're advising him of his rights, and it's important to do that in our system because a lot of people don't know what their rights are, as we've talked about so much on this channel. But when you have something this serious staring you in the face, you need to make sure you know what your rights are.
to go over the criminal complaint with you.
And he audibly says he understands what his rights are.
Count 1 of the criminal complaint charges you with the felony offense of burglary. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022, in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder, in violation of Idaho Code 18-1401 and 1403. The maximum penalty for that offense, if you plead guilty or are found guilty, is not less than 1 year in prison, no more than 10 years in prison, and/or a $50,000 fine or both. Do you understand?
Yes.
Count 2 alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died, in violation of Idaho Code 18-4001, 4002, 4003, and 4004. The maximum penalty for this offense, if you were to plead guilty or be found guilty, is death or imprisonment for life. Do you understand?
Yes.
Count 3 alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Kaylee Gonsalves, a human being, by stabbing Kaylee Gonsalves, from which she died, in violation of Idaho Code 18-4001, 4002, 4003, 4004. Again, the maximum penalty for that offense, if you plead guilty or are found guilty, is death and/or imprisonment for life. Do you understand?
Yes.
Count 4 alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing Xana Kernodle, from which she died, in violation of Idaho Code 18-4001, 4002, 4003, and 4004. Again, the maximum penalty for that offense, if you plead guilty or are found guilty, is up to death and/or imprisonment for life. Do you understand?
Yes.
Count 5 alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died, in violation of Idaho Codes 18-4001, 4002, 4003, and 4004. And again, the maximum penalty for this offense, if you plead guilty or are found guilty, is up to death and imprisonment for life. Do you understand?
Yes.
And Mr. Kohberger, would you like to represent yourself, hire a lawyer, or see if you qualify for court-appointed counsel?
I have court-appointed counsel.
Court has reviewed
All right. So we get an answer there. Is he going to represent himself? At this point, answer is no. Could that change in the future? As we know with every case we've seen somebody represent themselves, yes, it can change in the future. It doesn't seem like he's going to hire his own lawyer. Right now, he seems satisfied with court-appointed counsel. That can change at any time as well.
Viewed your application for attorney at public expense. I do find that you are indigent and do qualify for court-appointed counsel. I will appoint Ms. Taylor to represent you in this case. Ms. Taylor, have you had an opportunity to speak with Mr. Kohberger about speedy preliminary hearing and setting this matter?
Your Honor, I have. We would ask the court to set the status hearing in a week or two to make a final determination.
Okay.
So that means it sounds like they have not made a decision as to whether or not they're going to demand speedy trial, but they do want a status hearing set within the next 2 weeks. And I know when she sets it already, but we'll go ahead and listen here.
And Mr. Thompson, Ms. Jennings are in agreement with that.
That's fine, State Your Honor.
I will go ahead and set this matter for a status hearing then on the calendar on January 12th.
January 12th, next Thursday, is going to be the status hearing. So we will put that on the calendar and we'll be talking about it at the end of next week.
At 10 o'clock a.m. We will make sure notice is sent. And then, Ms. Taylor, do you wish to argue bail at this time?
Your Honor, I would like to ask the court to consider setting a bond. Mr. Kohberger right now is on a no bond hold.
So you don't have to. You can set a separate bail hearing. This lawyer has decided to argue bail right here. What do you think the judge is going to do if you don't know already? Do you think she's going to give Bryan Kohberger bail?
Limited request as I don't have enough information. We are new to the case. We have reviewed very much in the way of information about the case, and we have just work on the case. But we would want to know that Mr. Kohberger has a good hand at this time.
And Mr. Thompson.
Your state's position is Mr. Kohberger is not entitled to bond in this case. The charges, as is noted on the arrest warrant itself. Article 19-816, 19-2903 both specify that given the potential penalties in this case, there's no right bail. The defendant was arrested 3,000 miles away across the country. We're examining he has to remain in custody.
And the fact that he was arrested 3,000 miles away is important, although it's not, it's not the same as, fleeing and hiding under a bridge somewhere when you just go to your parents' house in your, childhood home or whatever, your old primary residence, but still point proven here.
At this point in time, pursuant to Idaho Criminal 46B and Idaho Code 19-816 and 2903, I am going to leave the bail set of this case as no bail at this point in time until I have additional and further information at a later date and time. So with that, then Mr. Kohberger, you will be remanded in custody and remain in custody on the no bail pending further proceedings in this matter.
He does not look the least bit surprised at that answer.
Is there anything further in the case then for today, Mr. Thompson?
Commissioner, the state is asking for no contact orders for various family members of the deceased and also for providing roommates. So briefly, the state should get into effect.
And Taylor.
No contact orders with the victims' families and the people that were in the house as well. That's very simple. Defense did not even object to it. It seems like that's going to get granted, was my guess. I haven't watched this whole hearing.
That is correct.
So I will go ahead and issue those no contact orders. So I do have a no contact order then for the named individual.
And yes, things happen in the law all the time that literally speaking and practically speaking don't matter. If he is in jail with no bond, then obviously he's not going to have contact with the victims' families or their survivors that were in the house. And if he broke out of prison, I don't think he's going to care about a no contact order. So, this stuff maybe practically doesn't matter, but it's a show of good faith. And it is something that the victims usually like and the victims' families usually like.
Of Dylan Mortensen, Bethany Funk, as well as the family members and Mr. Chapin, the family members of Ms. Kernodle, Mr. and Ms. Laramie, Mr. Mogan, Ms. Cheeley, and then a number of members of the Gonsalves family. Those specific names will certainly be provided to you, Mr. Kohberger, by way of being provided notice of these documents. You'll get a copy of these no contact orders. What you do need to be advised of and what will be in this no contact order is you are prohibited from having any contact with them whatsoever. You cannot contact them through a third person in writing or by any electronic means. cannot Facebook, Snapchat, Twitter, Instagram, use the phone to communicate with them or otherwise any form of communication in direct or indirectly with them. You cannot engage in any conduct that would harass, stalk, threaten, use, attempt to use, or threaten to use any physical force or violence upon them, or place them in reasonable fear of bodily injury. You cannot go within or knowingly remain within 300 feet of their person or their home, workplace, or any other place where they
Very standard no contact order.
might be. There are no exceptions to these orders, and if you do violate these orders, it is a new misdemeanor offense. It is punishable by up to a year in jail and or a $1,000 fine or both. At this point in time, due to being in the magistrate's division here, at this juncture, I am going to issue the no contact orders for a period of 2 years, and then if it needs to be modified or changed by additional judge, it can be done so at that time. Is there anything further, Mr. Thompson? Anything further, Ms. Wheeler? No, all right, thank you. We are adjourned.
All right. So that is hearing number 1 here for Bryan Kohberger. I am going to get to your questions now, but it's really interesting, right? Every time we're going to see it, he looked very composed. He was agreeable. They didn't fight everything. He understood everything. He understood all of his rights. No Daryl Brooksisms there. So it's going to be interesting. It's definitely something that we are going to follow along with. If you haven't hit that like button already, go ahead and hit that like button. We're getting close to the end of the video. Subscribe if you haven't already and get your questions in here. I've got about 5 minutes here for questions. Are you planning to cover the updates on Petito Laundry civil trial? Yes, I am planning to. I just don't know when I'm going to get around to it because so much is happening on this case. And most of the requests, Instagram and Twitter at Tragos Law, if you want to give me a follow there. A lot of people ask for content there, and this has just been dominating my DMs at this point. So that's why I'm kind of sticking to this case for right now because it's the content most people are asking about. Carrie Sutton, would BK leave DM as a witness? Sociopath. Getting inside the mind is difficult. Emma, here's your question. If their crime scene reenactment experts find all is showing he's guilty, does he have to disclose this? So you do not have to disclose expert opinions if you just talk to the expert and they say, hey, this is going to be bad for you. Usually that's how it goes. They don't like write out a full report. If they do produce a report in some jurisdictions, you do have to produce that in discovery. So I don't know specifically what the criminal discovery rules are there, but if they just talk to an expert, that doesn't have to be disclosed. You can just say, oh, we're not going to use that expert. Question, Peter, since he crossed state lines to commit the murders, could it become a federal case? No, it's not going to become a federal case because of that. Kathleen R. Interesting how the camera avoids staying on BK. Did Vallow Daybell judge decision set a standard? I would think that the media companies want to stay a little further away from the line than what happened in Vallow Daybell because they do not want to be booted out of the courtroom again. Kim D is going to be attending the Vallow case if possible. That's awesome. We'll have to get in contact to see what's going on since there will be no cameras in the courtroom. Daniel Boberson, do you think high-profile defense attorneys will want to get involved with this trial? Thanks. It's possible if somebody thinks it's winnable. I don't think if anybody thinks this guy has no chance that they're going to want to go lose the case like this. My guess right now is it's going to end up being an appointed lawyer. Allie Foley, Bryan Enton posted the order to preserve the crime scene for the defense earlier this afternoon. They have until February 1st to collect their evidence. Yes, and that was one of the big things about cleaning the house. Like, just couldn't believe that they would start cleaning it before the defense experts got to go in there, and they are going to potentially put together some reenactment, and they've got experts already reportedly. Kathleen Sikarsky, what's a status hearing, please? A status hearing is kind of what it sounds like, a status of what's going on in the case. They can either waive speedy trial or let the court know they're going to do demand a speedy trial. They can ask for something like to preserve the house so that they can get experts in there. They can say they can change their plea to guilty. A lot of things can happen at a status hearing. And sometimes it's like, hey, judge, we just have to kick the case out another month. Let's have another status hearing in a month because nothing's happening right now. Cleo Goodwin, he appears so normal. It is so hard. And we're going to have this answer and question throughout the entirety of this case. It's impossible to get in the minds of some of these people, you know, whether he did it or not. It's just very difficult to do. Nancy L., is he allowed contact with his family, or is that not allowed? That is absolutely allowed. The no contact orders with the victims' families, like the Gonsalveses, and the surviving members of the house that were there. T. Snyder, what is telling for me is he isn't protesting his guilt. I'd be protesting. I'd want everyone to know I'm innocent. Yikes, his mannerisms don't look right. So he is protesting his guilt by pleading not guilty, right? And by not admitting it and not pleading guilty to this point. But I do agree with you that if you want to get into what you would do or what I would do when they're reading those charges. Maybe hang your head, maybe shake your head, maybe saying, no way, it wasn't me, whatever. I get what you're saying there, but sometimes criminal defendants are more reserved. Sometimes people are just scared out of their shoes, and they just don't know what to do or don't know how to act or react. He does seem calm, and you can read into it by seeing it. But again, we don't want to go too far, because nothing that's happened so far is evidence, and we don't want to use those cameras and facial expressions to try to convict somebody based on that. But I totally get where you're coming from. All right. So that's all we've got for today. Next week, we're going to do more Idaho content. So there's another hearing happening. I will try to get to Petito Laundry, and then we'll also do some Sarah Boone updates. She's got a hearing on January 17th. That's her pretrial hearing. So we've got a lot to follow. Follow me on Instagram and Twitter if you want to get involved in picking the content. Become a member if you want kind of extra votes at picking the content. We're going to run some polls on there to help us pick what content we focus on, since a lot's going on right now. We're going to do some fun member stuff too in the new year here. So thank you everyone so much for joining us. Yes, we are still sending prayers to Rich Hogue and his family, to Rick. Thank you, Angela, so much for posting this in here. So make sure you go give him a follow as well, and send some tweets out to Rick and his family. I appreciate everyone being on here. This was an interesting conversation as always. I feel like I learned something. Hopefully you guys feel like you learned something. We'll go out here on P-Hop. Will his attorney ever ask him if he did it, or did it if he doesn't confess? That depends on the attorney. Most, I would say, don't ask that specific question. But some do. So we'll see. Appreciate all of you as always. I'm out of here. Hope everyone has an awesome